Today we have with us Mr. Namit Saxena. He has previously clerked with the Judge of the Supreme Court of India and is currently practicing in the Supreme Court. He is also the revising author of various law books. So today we'll be discussing about the recent controversy about the judges' press conference, independence of judiciary, etc. So let's begin.
So, sir, the first question is in the light of the recent controversy that occurred in the Supreme Court of India. Now, when the judges made public appearance via press conference, some claimed that this was a historic step that was taken by the judges. Some, on the other hand, say that the judges should not have done this. Now, what do you think? Should the focus be on what they said, or should the focus be on how they said it?
The focus is, Pratap Bhanu Mehta recently wrote in Indian Express, the focus should be on what they said rather than how they said it. So, regarding this recent controversy, you'll have to go few months back as to what led to this controversy, if this can be called a controversy at all. I don't personally feel it's a controversy. So it is something which which had to come out, and if judges won't judge the judges, who is apart from the bar, there is no power to judge the judges as well. So the whole background to this is that the Chief Justice of India, particularly, it is not the Chief Justice of the Supreme Court. Like in High Courts, we have Chief Justices of the High Courts, not of the states. Like for example, Rajasthan, the Chief Justice of the Rajasthan High Court, and not the Chief Justice of the state of Rajasthan. Similarly, in fact, diametrically opposite to that, we have the Chief Justice of India, and not the Chief Justice of the Supreme Court. So the powers and the consequent responsibilities are much more on the Chief Justice of India. Now, Chief Justice of India, to carry on the responsibilities, he is given a lot of administrative powers. One such administrative power is to decide the roster as to what will be the composition of the bench, and what kind of cases, what type of cases will a particular bench decide or hear to. Like for example, in Supreme Court, there are minimum 2 judges apart from the chamber matters. 2 judges sit, and then 2, 3, 4, 5, 6. Well, generally they sit in odd numbers. Initially they used to sit in even numbers as well. So now the Chief Justice is the master of the roster. But the roster is not of the master. The roster belongs to the countrymen. For example, and especially the litigants, as to who who is allotted a particular category of cases and who deals with a particular category of cases apart from it. Now the Chief Justice of India in his wisdom decides that okay, this category of cases will be decided by this particular bench or so. Now the roster is not fixed, it is quite random in the Supreme Court, and it can't be said that only this bench is there's a criminal bench or there's a tax bench. It does not work like that in the Supreme Court, unlike High Courts. So the Chief Justice of India allocates matters. So we had this medical bribery scam which was raised by Mr. Prashant Bhushan. Mr. Dushyant Dave is a very distinguished member of the bar, and Kamini Jaiswal, then CJAR. That issue had involved indirectly the Chief Justice of India and the bench led by the Chief Justice of India. So when that matter was, because the Chief Justice of India at that point of time was sitting in a constitution bench. So as a matter of convention and as a matter of practice, no mentioning is done before the Chief Justice of India or the Chief Court or any constitution bench for that matter. So that matter was mentioned before Court number 2, which is a routine practice, Justice Chalmeshwar. So Justice Chalmeshwar found in his wisdom that something needs to be done, and then he said that okay, a bench of 5 judges of the 5 senior most judges of the court will hear it. Now there are 2 things. Now Justice Chalmeshwar was right in appreciating that this involves that this needs consideration, but then he overstepped his authority and constituted a bench. That too, constituting a bench of 5 senior most judges of the court. Now that power rests with the Chief Justice of India. What Justice Chalmeshwar could have done is, okay, this is something very, something which deserves a response urgently. He could have, traced it to the Chief Justice, said, okay, please constitute the appropriate bench as soon as possible, because the power rests with the Chief Justice. Now Justice Chalmeshwar overstepped. Now the other matter was before Justice Sikri and Justice Ashok Bhushan. That matter came up, and that was that should have been ideally tagged with the main matter, Justice Chalmeshwar's order. But then Justice Sikri said, okay, he did it right, that okay, let the Chief Justice of India tag it to the appropriate bench. Now the Chief Justice of India, in a sudden response, or maybe, in his wisdom, then he constituted a 7-judge bench and then a 5-judge bench to indirectly nullify the order passed by Justice Chalmeshwar. Now the constitution of that bench is, something which created controversy. That bench constituted of Justice Arun Mishra, Justice Agarwal, Justice Khanwilkar, the Chief Justice himself. So the first question raised was, this is violation of principles of natural justice, because allegations were against the Chief Justice. So he could not have been the part of that bench. Allegations indirectly, I'm saying all this is indirect. He's not named in the FIR. And these are all allegations. The main prayer was to, constitution of an SIT. So the Chief Justice of India could not have been in the bench. Then the second allegation, the second aspect of the allegation was that you handpicked few selective judges and, your favorite judges and constituted them, overlooking that, there's a judicial order passed saying that top senior most judges of the court will hear it. So that again, triggered a lot of controversy. Then there were other matters, a matter was that MO period, which was there in the letter as well. Then it, now the Supreme Court, there is no intra-court appeal. So you can't, just simply overrule a matter, post it before yourself, So all these, created this. So there is, what you call a tussle between few judges and the Chief Justice of India regarding selective posting of matters. I don't personally feel that's a controversy. It is something which needs to be addressed. Now, the Chief Justice of India is the captain of the ship. He has to carry the court with himself. There is only one Supreme Court. They sit in 15 different benches, but there is no 15 different Supreme Courts. There is only one Supreme Court. So the Chief Justice of India, as the captain of the ship, should carry them with themselves. It is here where the problem is. So I hope it will be resolved soon, and let's see.
So sir, a follow-up question, like the master of the roster. So can such kind of a mechanism exist without any checks or balances? Like so much concentrated power in one person, the CJI, without any checks or balances. Like should it exist? And like what should be the follow-up?
It has to exist, because the power of allocating benches, allocating matters and composing benches has to rest with somebody. And it can't be a body. There was this suggestion that okay, top 3 judges, like the collegium said, 3, 1 plus 2, 1 plus 4. A body of 1 plus 2 or 1 plus 3 judges of the court may decide the roster of the matters. But that power, even under the Supreme Court rules, that is with the Chief Justice of India.
So can't they follow up a mechanism like the Delhi High Court follows? You mark the roster, like no controversy at all. Like
that will be rather bad for the Supreme Court, because Supreme Court is the highest court of the country. Now, for example, like what happens in the High Court is that, and I'll tell you because we practice from the practitioner's point of view. So if a High Court has a particular bench, say roster, so we generally speak to each other, ki yaar, in Hindi if I may say so, ki yaar uska roster kiska chal raha hai. So for example, 482 section 482 CRPC petitions are heard by a particular bench. Then orders get influenced by the ideology of the judge. They become judge centric. For example, at the bar we generally speak to each other, ki yaar uska chal raha hai, he's a negative judge. We won't file it now, we'll file when the roster changes. That thing should not happen and must not happen in the Supreme Court.
So that bias is weeded out.
That bias is completely weeded out, because the posting of the matters is quite random. Like for example, like a lot of criminal matters are posted before Justice Goyal and Justice Lalit, because Justice Lalit was an expert in criminal law. So if you file a criminal SLP, that may go before Justice Goyal and Justice Lalit's bench, but it may also go to any other 13 benches. So that randomness is actually good for functioning of the court.
So you talked about this allocation of cases to various benches. So one of the aspects that we came across while reading the letter that was given by the 4 judges was that the CJI was selectively allocating cases without any rational basis. So what do you think? Should we change the method of appointment of CJI? Or should we stick to the present system that we have, like seniority convention, or should there be any other?
When the Supreme Court was formed initially, as a matter of fact, so Justice Patanjali Shastri, Justice K. Kuji, they had a little order. In fact, the whole Supreme Court, threatened the then Prime Minister and the Law Minister
Yes,
that will resign.
Right.
So then this seniority convention came as a matter of respect as well, that the senior most puny judge should become the CJI. But the CJI recommends, the outgoing CJI recommends the incoming CJI. But in the second judge's case, they laid down that the senior most judge of the court, senior most puny judge of the court will become the CJI until unless he is fit to hold the post. Now the criteria of fitness is not defined. Now, for example, if I'm not me, if Chief Justice Deepak Mishra tomorrow says that okay, I don't consider the incoming puny judge Justice Ranjan Gogoi to be fit to hold the post of CJI. Now this fitness is in the larger sense. Also fitness and suitability are two different things. So fitness, and it does not should not be suitable, only fitness. So fitness can be treated as physical health. And I'm not physically, if somebody is not physically well to hold the post of the Chief Justice, then you can say that he's not fit. But the criteria of fitness is very called undefined. Now, an outgoing CJI may say, okay, I don't consider him fit to hold the post of CJI. So all this is a little dicey, but now it is laid down that second puny judge will take over.
So, sir, like the question of political.
In fact, the administrative powers are handed over much before CJI actually superannuates.
So, like the question of political affiliations, don't you think like we should follow the US model? Like before like appointment, there's a hearing. Everyone knows that this very particular person is a Republican or a Democrat. Because judges too are humans. They are voted throughout their life. They are being appointed to the High Court at the age of 45, 46. So by that time, everyone has a political affiliation at the end of the day. And it cannot be said that as soon as they assume like the judgeship, the political bias, the affiliation is totally gone. So shouldn't they openly declare like, yeah, I am a right winger, I am a left winger, all of that?
No, they shouldn't. And see, law and politics go hand in hand. And judges, at the end of the day, if you'll consider them the basic, the element, that is, these are political discretionary appointments. So, political affiliations help you in getting elevation. But once you are appointed as a judge, once a person gets the authority of holding a post in a constitutional court as in the capacity of a presiding officer, all these political affiliations and all these are sidelined. So only because of somebody's political affiliations, or only because of somebody's maybe relatives may be in politics, or somebody may have been a member of some political party or affiliated somebody. But then all these factors should not be given weightage over someone's merit to be a judge and decide cases in the interest of justice.
So you talked about the merit and political affiliation. So the question is like after post-retirement phase. Now, do you think this post-retirement appointments that we see, do they erode judicial independence? Like for example, we have seen how Justice Satta Sivam accepted governorship. So what could you say about it?
I think, post-retirement jobs for judges, they hamper judicial independence somewhere. It can't be, completely negated that, because we have seen a lot of examples where, immediately before superannuation, judges, tend to either not decide cases or, release them from partner at the end of the day, and, or give a favorable adjournment or a favorable order to, the government or to select few. All this happens. So, post-retirement jobs hamper this. This can't be doubted,
So the last question is about the collegium system. Like, should it stay, should it go? What other mechanisms should take over?
See, the present system should be improved. NJAC was not something which, which would have helped getting the system or the mechanism better. NJAC would have injected a political interference. Once political interference established through a statute book comes into judiciary, that too at the threshold of appointments, then independence slowly gets eroded. So collegium is there, but collegium now, earlier it was very opaque. Now due to efforts made by Justice Chalameshwar, they have this categoric collegium resolutions. And so anybody can see the meetings, minutes of the meetings of collegium resolution, that what all was discussed. but it needs to be improved further. And and it is not like that, the three people sit in a closed room, they sip coffee and decide, I will appoint this. It's a very hefty exercise. They call people, they call lawyers, they take views of the judges who have come to the Supreme Court from that particular High Court. They consider a lot of factors. Then there's IB check, etc. A lot of things are there. It's not that something completely absurd happens within four walls. But yeah, a lot of factors play a role: regionalism, religionism, caste, political affiliations. All these factors play a role. So it needs to be much more transparent, because Supreme Court, it's the highest court. Whatever they decide is the rule of law, and it is rather law under Article 141. So they need to be more cautious in this. The mechanism may be improved. There are a lot of suggestions, but it deserves to be improved. But it should not be completely brushed aside or shrugged off through an indirect political interference route like NJC.
Thank you.
Thank you, sir.
Thank you.
Thank you.